Are you an employer that cannot meet recruitment requirements through traditional visa pathways? A labor agreement may be your solution. My name is Willem Oostdyck. I'm a senior migration advisor at Sirus Migration. We at Sirus Migration are here to help you navigate the immigration system, answer your questions, and/or offer solutions. In this video session, we are sharing some insight about the labor agreement and review some of the types of labor agreements that are available. A labor agreement is a formal agreement between a minister and a person or organization. A labor agreement allows you to sponsor skilled overseas workers when traditional visa programs are unavailable. Those visa programs are temporary skill shortage or subclass 482 visa, employer nomination scheme, subclass 186 visa, and the skilled employer sponsored regional subclass 494 visa. How do we know a visa is available for sponsorship or not? When we find that the occupation we're seeking to recruit for is not on the skilled occupation list. Generally, you can only sponsor foreign workers to fill a role on the skilled occupation list. Some of those lists are the Medium and Long-Term Strategic Skills List, MLT-SSL, Short-Term Skilled Occupation List, or the STSOL, and the Regional Occupation List, ROL. Well, where standard temporary or permanent skilled visa programs are not available, and the employer's recruitment needs cannot be met through the Australian labour market. Labour agreements provide a flexible solution for employers. It is important to note that an employer must be able to prove they need to fill this role for the business to operate and cannot find an Australian worker with the necessary skills. Labour agreements are generally in effect for 5 years and include additional terms and conditions as well as additional requirements. The reason for this is that a labour agreement sits outside the legislative framework as opposed to the traditional visa subclass, which are governed by immigration regulations. Labour agreements are governed by departmental policy. There may be circumstances in which the occupation of the worker you want to hire is on the list. However, you wish to waive some of the specific skills and experience requirements standard for the visa eligibility, such as age, English requirements, education qualifications, or years of experience. Concessions may be negotiated to the occupation criteria for a worthy employee under a labour agreement. An employer must evidence there is strong justification that it will benefit your business, and minimum standards are met in relation to qualification and experience, such as meeting Certificate 3 and the need for 3 years of relevant work experience. It typically takes 4 or 5 months to prepare a labour agreement, which involves strict negotiations with the Department of Home Affairs, lengthy industry consultation, and drafting of a written agreement. Processing of the agreement can take up to 6 months. Please note that the Australian government is under no obligation to enter in a labour agreement. If successful, it would generally last for 5 years. Depending on your situation, the types of labour agreements available are company-specific labour agreements, industry labour agreements, designated area migration agreements, and project agreements. Company-specific labour agreements are individual agreements solely for your business. It is distinct to your business and the particular occupation and the visa you will use for the workers in question. Usually negotiated with Department of Home Affairs on a case-by-case basis, this agreement should be considered if the occupation you are seeking to fill is not available under an existing industry labour agreement. To qualify, you will need to evidence that there is a genuine skills shortage or labour shortage in the Australian labour market that warrants hiring a foreign worker to perform this role, and you have undertaken labour market testing and extensive consultation with industry stakeholders. Showing that there is a genuine labour market need for the position that cannot be filled locally is a crucial part of your application. You will need to establish that your need to recruit overseas workers is only a temporary solution. The overseas hire must only be sought to supplement your Australian workforce, and the foreign workers cannot form more than 1/3 of your total workforce. In your application, you will need to provide evidence that you are a registered and financially viable business that has been operating for at least 12 months, are seeking to fill skilled occupations that have been omitted from the ordinary occupation list, and will meet the salary and employment conditions for the occupation. You will also need to demonstrate that the foreign worker has the appropriate skills, qualifications and experience to carry out the role, and proficient English language skills, unless the Minister of the Department of Home Affairs provides special permission. The company's specific labour agreement is for an employer where a genuine skills need is not already covered by an industry labour agreement, or a designated area migration agreement or project agreement is not in place. You must show us that you have an exceptional need that cannot be met by Australian workers. You need to provide evidence of the niche skills you seek from overseas, of your many and diverse recruitment efforts, and showing a detailed job description including tasks. Industry labour agreements, as opposed to company-specific agreements, is for jobs in specific industries with fixed terms and conditions. An existing number of industry agreements are in place, including for jobs in these sectors: dairy, fishing, meat, religion, on-hire, pork, fine dining, advertising and horticulture. These agreements are negotiated between the Department of Home Affairs and key industry stakeholders, such as unions or industry bodies. An industry is typically considered for an industry labour agreement when the department receives similar labour agreements applications from many businesses in one industry, there are clear labour shortages in that industry, and there has been an extensive consultation within the industry. The industry-specific labour agreement cannot be negotiated for further concessions. Terms and conditions in the agreement are binding. The next labour agreement are the designated area migration agreements. This agreement is applicable for a particular geographic region that has a particular demand for labour with the necessary skills or labour supply. It is a formal agreement between the Australian government and a regional, state or territory authority. It allows particular regions to respond to their unique economic and labour market conditions. Some examples of DAMAs include the Northern Territory Designated Area Migration Agreement for the Northern Territory, the City of Kalgoorlie-Boulder DAMA for the goldfields in WA, the Warrnambool City Council DAMA for the Great Southern Coast of Victoria, Immigration South Australia for the Adelaide City and Regional South Australia, a Regional Development Australia DAMA for Orana, New South Wales, and Cairns Chamber of Commerce DAMA for Far North Queensland. A DAMA consists of an umbrella agreement between the Australian government and a particular region. It lasts for 5 years, under which individual labour agreements may be settled with employers from that particular region. A DAMA may be most suitable for smaller businesses that do not have the capacity to enter in a company-specific labour agreement. The final of the agreements is the project agreement. Your business may seek a project agreement if you experience or foresee a skills shortage during the construction phase of a resource or infrastructure project. It is in effect like a DAMA. A company involved in the specific project will negotiate an overarching deed of agreement with the Department of Home Affairs. Then, as a business involved in the project, you can negotiate and agree upon an individual labour agreement in accordance with the project agreement. So in summary, as we discussed in this session, labour agreements offer your business an alternative to the standard business sponsorship schemes. This is particularly useful if you want to hire an employee who is not covered by the listed occupation or does not meet the eligibility criteria for the visa. Depending on the circumstances of your business, you could apply for one of 4 potential labour agreements options. These include company-specific agreements, if your business needs a distinct agreement to continue operating, industry labour agreements, if your business falls under one of the 9 existing sectors, designated area migration agreements, if you are geographically positioned in an area with specific needs or labour shortages, and project agreements, if your business is working on a specific project. Labour agreements are negotiated with the Department of Home Affairs on a case-by-case basis. To qualify, you will need to evidence that there is a genuine skills shortage or labour shortage in the Australian labour market that warrants hiring a foreign worker to perform this role, and you have undertaken labour market testing and extensive consultation with industry stakeholders. If you require further information or specific immigration advice regarding labour agreements, then contact us at admin@sirus.com.au or book a consultation with a registered migration agent who can provide you with any further advice in respect to labour agreements. If you found this session informative, like this video and subscribe to our channel for future videos like this one.